Let's talk about something incredibly important: sexual harassment in the Swiss workplace. This is a topic that really does affect every single one of us. Understanding your rights and what your company is legally required to do is absolutely the first step to making sure our workplaces are safe and respectful. And just so we're all on the same page, this is not some rare, far-off problem. The reality is, many of us, if not most, will run into this in some way during our careers. That's exactly why being informed isn't just helpful, it's your best line of defense. So here's how we're going to break it all down today. We'll start by looking at just how widespread this issue is. Then we'll get into the nitty-gritty of what sexual harassment actually is under the law. From there, we'll cover what your employer has to do, what your rights are, and the powerful legal protection you have, before we wrap it all up with the key takeaways.
All right, let's jump right into Section 1. Because this issue is so common, getting a handle on the rules is just essential for everybody, whether you're an employee, a manager, or a business owner. Okay, on to Section 2. Now, to really understand our rights, we have to be super clear on what sexual harassment is in the eyes of Swiss law. And you might be surprised, the definition is actually quite simple, but it is incredibly powerful.
And there it is. That's the core of it. Any behavior of a sexual nature that is unwanted. It can be words, it can be gestures, it can be actions. The key word, the one that changes everything, is unwanted. It's a simple term, but it makes the definition incredibly broad. Now this is probably the most important thing to grasp in all of this. The law does not care about the intent of the person doing the harassing. So that classic excuse, "Oh, I was just joking," yeah, that's not a legal defense. What truly matters is the subjective experience, how the person on the receiving end feels about it. If they perceive it as unwanted, it can be legally defined as harassment, period. So, what does this look like in the real world? Well, it can be a whole range of things. It could be inappropriate comments about someone's appearance, or those so-called sexist jokes. It could be sending or showing pornographic material, unwanted touching, or even unwanted invitations. And of course, it covers the really serious stuff, like making threats or any kind of assault. This isn't a complete list, but it gives you a really good idea of how wide that legal net is cast. Okay, so if this stuff is happening, who's responsible for stepping in? Well, Swiss law is crystal clear on this one. The primary responsibility falls squarely on the employer. They have a legal duty to protect their people. This legal idea is called the Pflicht, which basically translates to a duty of care. It legally obligates employers to actively protect the personal integrity and health of their employees. And let me be clear, this isn't just a friendly suggestion, it's a legal command. It means they have to take steps to prevent harassment before it even starts, and to step in decisively if it does. So what does this duty of care actually look like? Well, it boils down to having a really solid prevention policy built on 4 pillars. First, you need a clear, zero-tolerance statement right from the very top. Second, everyone in the company needs to know exactly what harassment is. Third, there has to be a safe, confidential place for people to go for help. And finally, there must be clear, stated consequences for anyone who breaks the rules. All right, now let's flip the script and look at this from the employee's perspective. If you're going through this, it can feel incredibly isolating, but it's so important to know that Swiss law gives you a clear, structured path to follow to get help and find a resolution. The process is designed to be accessible, and it happens in 3 stages. You start by going through the internal channels that your employer is required to have. If that doesn't work, or maybe it's just not an option, you can take it to your local cantonal conciliation authority. Now, this is a huge step because this is a neutral body, and get this, it's completely free of charge. If that mediation process doesn't lead to a solution, then you have the right to take your case to court. One of the biggest fears that stops people from speaking up is the thought of losing their job. And this is where one of the most powerful tools in Swiss employment law comes into play, the Gender Equality Act. The Gleichstellungsgesetz, or GELG for short, is a big deal because it specifically recognizes sexual harassment as a form of gender discrimination. And because of that, it provides a really robust shield against something called Rachekündigung, which is basically just a retaliatory firing. It's when you get fired because you stood up and made a complaint. And right here is where you see the unique power of this law. Under standard labor rules, if you get fired abusively, the firing still stands. You could sue for some money, sure, but you can't get your job back. But a retaliatory firing under the Gender Equality Act? That's totally different. It is contestable. That means a court can actually rule that the dismissal is void. You could be reinstated. That is like massive game-changing difference.
And this legal shield isn't just for a day or two. It follows a very specific timeline. It kicks in the second you file a complaint, whether it's inside the company or with the official authority. It stays with you through the entire process. And this is so important. It continues for a full 6 months after your case is officially closed. The law creates this protected bubble so you can speak up without fearing immediate backlash.
Okay, we have covered a ton of ground here. The definition, the duties, your rights, and the legal protections. So let's boil it all down into the most critical points that you really need to take away from this. For employees, please remember these two things. First, it is your perception of the behavior that legally matters, and there's a formal process you can follow. Second, the law gives you incredibly strong protection against being fired for speaking up. Now, for employers, your takeaways are just as crucial. You have a legal duty of care to prevent and to stop harassment, and your single most powerful tool to do that is a clear, comprehensive, and well-communicated policy. And that really brings us to our final thought. A policy written down on paper is one thing, but a true culture of respect is something else entirely. So the question I want to leave you with is this. Does your workplace just react when there's a problem, or does it have a culture that actively prevents harassment from ever taking root in the first place? Thanks for joining me.